Iowa District Court for Sac County is now in session. Judge Bill Asselin presiding.
Thank you for standing. Please be seated. Court is now convened in criminal number 12518, State of Iowa versus Christopher Walt Carnine or Carnine. Bob Peterson's your lawyer. He's seated next to you. Ben Smith here representing Sac County and the state of Iowa. A number of interested persons in the courtroom as well. The court has convened today to enter final judgment sentencing for Mr. Carnine, having accepted pleas of guilty to a number of counts. I need to grab something from the other room. Mr. Carnine was found guilty on 4 counts, 2 counts of sexual abuse in the 2nd degree and 2 counts of sexual abuse in the 3rd degree, all felonies which required the court to order that a pre-sentence investigation be prepared to assist court and counsel on this date. I received a copy of the same, and I believe counsel has as well, but I'll make inquiry of that momentarily. Mr. Smith, are you ready to go?
Yes, Your Honor.
Mr. Peterson, are you ready?
Yes, Your Honor.
Mr. Carnine, you know why you're here today?
Yes, I do.
You had a chance to visit with your lawyer?
Yes, I have, sir.
You satisfied with the discussions you've had with him?
Yes, sir.
Very well. Mr. Peterson, have you received a copy of this pre-sentence investigation? Are there corrections that need to be made, and do you object to its use?
Yes, Your Honor, we have received a copy of the pre-sentence investigation. Mr. Carnine has reviewed it. He has no additions, deletions, or corrections, and no objections to its use today.
Mr. Smith, same questions to you.
Same answer, Your Honor. No additions, corrections, or deletions.
Very well. Does the state wish to present any evidence?
No, Your Honor.
Does the defendant?
No, Your Honor.
I would hear the state's sentencing recommendation.
Thank you, Your Honor. State sentencing recommendation is as follows. As to counts 2 and 3, set forth in FECR 012518, both of which are Class B felony sex abuse crimes, which require, among other things, that defendant be sentenced to prison and that he serve bare minimum 7/10 of that sentence before he's eligible for parole. And that didn't state so that those 2 counts, counts 2 and 3, would run consecutive to one another. As for count 1 in that same docket ending in 518, the state is recommending that that Class C felony 10-year sentence run concurrent with the previously mentioned consecutive Bs.
Those are all in criminal number 12516. 518.
Yeah, 518, Your Honor.
Very well.
And the remaining one, the same crime in count in docket ending in 516, which is also a 10-year, carries over to the 10-year sentence, and that the state has agreed that that should also run concurrent with the Bs that are running consecutive. The state's made this recommendation. I guess defendant's guilty plea and the state's recommendation in this matter came as a result of extensive negotiations with defendant through his attorney Bob Peterson. In consideration for defendant's guilty plea and agreement to be sentenced as previously discussed, the state has agreed that it will not bring any other charges based on the facts and circumstances alleged in the trial information, which, as the judge is able to see, is alleges a significant history of sexual abuse on a number of different victims. The state has further agreed not to prosecute in the event defendants' electronic devices, after being analyzed forensically, return depictions of child pornography. The state has agreed not to prosecute those as well, and so has the federal government. To a certain extent, they have provided myself and defendant with a letter indicating as much. The state has also agreed that the fines imposed should be suspended, and I think most importantly in consideration for this, the state has agreed not to put on live witnesses at sentencing, not to raise any material or any subject matter outside the defendant's factual basis he provided in the guilty plea for the court's consideration, such that it might save embarrassment not just to him, but as to the victims who so far have been kept fairly anonymous. I believe that is the state's recommendation and the basis for it, Your Honor. Thank you.
Mr. Peterson, is that the sum and substance of what has been discussed with you and you in turn relayed to your client?
Yes, Your Honor.
Just to make a complicated matter a little simpler, my interpretation of what the state's recommending would be 2 Class B felonies to run consecutive, totaling 50 years. Those sentences being mandatory sentences of at least 7/10, and the other counts would run concurrent. So we're talking about a 50-year imposed sentence with the minimum being 35 years. Mr. Smith, is that accurate?
That is accurate, Your Honor.
Mr. Peterson, do you agree?
Yes, Your Honor.
Have you explained that to your client?
Yes, Your Honor.
Mr. Carnine, do you understand all of this we've talked about and the reality of what the sentencing is likely to be?
Yes, I do, Your Honor.
You've consented to that recommendation?
Yes, Your Honor.
Mr. Peterson, do you intend to put on any evidence?
No evidence, Your Honor. My client, he did plead to avoid embarrassment to the victims. And he is sorry for what has happened, sorry for the problems that were created to the families, the state. He does want to, I believe, still express his apologies personally. But he did agree to the plea offer, basically because of his remorselessness.
Very well. Mr. Carnine, you heard the lawyer speak. You heard your lawyer explain to you that, explain that you were remorseful about this. Is it your desire to say anything to the court at this time?
My apologies to everybody and the families and the court system. Greg is doing all this. I appreciate the time and effort.
Okay. I need to go through with you the parameters of the sentencing options one final time. And I think the simplest thing to do is to point out to you that In criminal number 12518, there are 3 counts. 2 counts of sexual abuse in the second degree, which are Class B felonies, and 1 count of sexual abuse in the third degree, which is a Class C felony. Each of the Class B felonies carries with it an indeterminate term not to exceed 25 years. These are what we would call forcible felonies, ones that require a mandatory minimum time served, which is 7/10. The Class C felony in 12518 carries with it a 10-year sentence with a minimum fine of $1,000, maximum fine of $10,000. All of these carry with it possible court costs, attorney fees, restitution. These are all issues that the court must consider. In criminal number 12516, this is a third degree sexual abuse Class C felony. Once again, this is a sentence that indeterminate sentence not to exceed 10 years with a minimum fine of $1,000, a maximum fine of $10,000. And in each fine instance, 35% surcharge would be added to the fines if they are assessed. Once again, court costs, attorney fees, and restitution are an issue. This is a complicated case. It involves 4 counts, and you've heard the word concurrent and consecutive uttered in this courtroom. Do you know the difference between a concurrent sentence and a consecutive sentence?
Yes, Your Honor.
All right. In this particular instance, there are special sentences involved. Pursuant to Iowa Code Section 9082.1, you shall not have the above sentence of incarceration reduced under Chapter 903 or otherwise by more than 15% pursuant to Iowa Code Section 901A. Defendant is hereby sentenced to an additional term of parole or work release to be determined by the Board of Parole not to exceed 2 years. The special sentence, the following sentence would be ordered, which sentence shall commence at the end of the sentence imposed for the underlying offense, and the defendant would be under supervision as if on parole as provided for in Iowa Code Section 903B.1 for the rest of the defendant's life. In addition, I think I pointed out to you that the two B felonies are mandatory sentences. You understand that?
Yes, Your Honor.
And finally, you will be required within 5 days of this date that the defendant should register with the county sheriff, or 5 days from the release from custody in the sexual registry, and pay the required $25 fee, which would require you to inform the county sheriff anytime you were removed. And violation of this requirement is an offense in and of itself. All of these things are part of the sentence, including the DNA, the provision of you providing a DNA sample. Mr. Smith, there's a lot of stuff here. Do you know of anything I've left out?
No, Your Honor, but there was one thing that the state did omit, and that was in agreement with the defense counsel and defendant prior to this, the state is wanting to add the three additional children that are subjects of that home environment that were not listed in no contact order.
Very well. Do you agree with that, Mr. Peterson?
Yes, Your Honor. I'm not sure if Your Honor, as part of the sentencing, mentioned fines and suspension.
I thought I did. The minimum fine in the Class B felonies is $5,000. The maximum on the C's is $10,000 with a minimum of $1,000 and 35% surcharge. Further clarification needed?
No, Your Honor.
Pursuant to Iowa Code Section 901.5, your term of incarceration may be affected by work credits, good conduct, and you might be eligible for parole before the entire sentence is discharged, taking into consideration the mandatory minimum. Mr. Smith, anything else?
Just that the state would, following this, would move to dismiss counts 1, 2, 3, and 4 in FECR 012516.
Mr. Peterson, anything else?
No, Your Honor.
Mr. Carnine, there's a purpose for the litany that we do at this time, specifically addressing the possible consequences or the parameters of sentencing. They're multiple, they're complex, and with the consecutive and the concurrent sentencing, any number of things can happen, most of which are dependent upon you. In this particular case, that certainly is affected by the mandatory minimums, but from this moment forward, most of your future is going to be in your own hands, supervised by the Department of Corrections. I reviewed the pre-sentence investigation. There's a significant history of criminal acts on your part. It's punctuated by substance abuse. There may well be reasons for your actions that are hidden in this report, your background, your education, your emotional stability, your use of drugs, your addiction to sexual matters, all of which have led you to this point today. And the recommendation that is included in the pre-sentence investigation coincides with the state's position. I do believe that the state has made significant concessions that may have prompted you to enter your pleas. I think some of which have been done to reduce further embarrassment for the victims and to protect them from public scrutiny any further, and may have been factors that you considered in pleading, understanding the nature of the state's position. I find that all the things contained in the report lead this court to the conclusion that the sentence that's been recommended is appropriate. It will therefore be the order of this court that the following sentence shall be imposed. As it relates to count 1 and criminal number, let's start with the 2 B felonies. In counts 2 and 3, in criminal number 12518, it will be the order of this court that you'll be committed to the custody of the Director of the Iowa Department of Corrections for a period not to exceed 25 years. The Iowa Medical and Classification Center in Oakdale, Iowa will be the designated reception center. These 2 sentences shall run consecutive to each other and shall be affected by the mandatory minimum sentences as identified in sections 902.12, which in short say that you shall serve at least 70% of the 50 years. The fine in this matter shall be waived. As it relates to count 1, sexual abuse in the 3rd degree, it will be the order of this court that you will be committed to the custody of the Director of the Iowa Department of Corrections for a period of not to exceed 10 years, and this sentence shall run concurrent with those imposed in counts 2 and 3 of 12518. The fine in this matter shall be waived as well. Count 5, contained in criminal number 12516, sexual abuse in the 3rd degree. It will be the order of this court that you'll be committed to the custody of the Director of the Iowa Department of Corrections for a period not to exceed 10 years. The Iowa Medical and Classification Center at Oakdale, Iowa will be the designated reception center. This sentence shall run concurrent to those sentences imposed in counts 2 and 3. The fine in this matter will be waived as well. In addition, you'll be required to pay what, if any, restitution is required of you. You'll have the right to challenge that in a hearing if you object. As I said before, pursuant to Iowa Code Section 901.8A.2.1, you shall not have the above sentence of incarceration reduced under Chapter 903A or otherwise more than 15%. And pursuant to Iowa Code 901A, you'll be hereby sentenced to an additional term of parole or work release to be determined by the Board of Parole not to exceed 2 years. In addition to the sentences imposed, the following sentence is hereby ordered, which sentence shall commence at the end of the sentence imposed for the underlying offense, and the defendant shall be under supervision as if on parole as provided for Iowa Code Section 903B.1 for the rest of the defendant's life. Pursuant to Iowa Code Section 901.59, and as clarification, counts 2 and 3 will count in criminal number 12518 shall run consecutive to each other, and counts 1 and counts 5 shall run concurrent to each other and concurrent to counts 2 and 3 in criminal number 12518. Pursuant to Iowa Code Section 903A.5 and 901.6, that you will be given credit for all time served in connection with this case. The term of incarceration is not sentenced. I want to make that perfectly clear. The law enforcement initiative charge is not applicable, nor is the DARE surcharge. There will be a no contact order entered and amended as pursuant to the state's oral statements in court today. Within 5 days from the date, this date, or from 5 days from the date of your release from custody, you shall complete all necessary sex offender registry forms as directed and pay the $25 sex offender registration fee. Pursuant to Iowa Code Section 692A, you will inform the county sheriff of any changes of address in this or any other state within 5 days of said change. Failure to comply sexual offender requirements will result in additional criminal charges. Pursuant to Iowa Code Section 692, you shall pay a civil penalty in the amount of $200. You will provide a physical specimen for DNA profiling. In the particular instance, I'll talk about the appeal bond in a moment. All outstanding bonds are exonerated, and the court will dismiss counts 1, 2, 3, and 4 in criminal number 12516. Mr. Carnine, what's taken place here is a tragedy for all, including yourself. You'll have to live with what you've done, and hopefully you'll be able to seek some help to see your way through this darkness. I pray that the people that are victims of your acts will succeed in reaching some sort of happiness in their life too. There are certain things that I've grown to understand. When a friend or someone loses a child, it's foolish for someone to say, "I understand how you must feel." That's wrong. I don't ever want to know that feeling. And likewise, I cannot put myself in the shoes or in the place of the victims in this case. I just pray for them, and I hope that someday they'll forgive you. Having said that, your fate is in your hands, and I hope that things go well for you. You have right to appeal what's taken place in these proceedings by filing a written notice of appeal within 30 days of today's date. If you can't afford a lawyer or a copy of the transcripts, one would be provided for you as well. Keep in mind, failure to file an appeal within 30 days of today's date precludes you from filing an appeal and pursuing it further. These are mandatory sentences. The appeal bond in this matter is not set. Mr. Smith, is there anything I've left out?
No, Your Honor.
Mr. Peterson?
Oh, yeah.
Of course it is.